I'm joined now by Republican State Senator Bruce Tarr, a co-sponsor of the bill. Thanks for joining us. So, Senator, did you come up with this, or some of the families approach you and you shared their outrage over this?
Well, the families did approach us, and at first what they sought was an amendment to the Constitution, essentially redefining what cruel and unusual punishment is to allow the continuation of life sentences without parole. But obviously that sets a very high bar to meet. It would take a long period of time. And, Emily, we may still pursue that. But in the meantime, we need to respond to the SJC decision that was delivered on Christmas Eve of last year, and the most practical way to do that is the statute that we've put forward.
So 15 is now what the state has said. All right, at 15 years in prison, they have a chance at a parole hearing. Not parole, a parole hearing. You came up with 35. That's a big leap.
Well, there's a range that we need to be in here in order to meet what I would consider to be constitutional muster. First of all, the range for life right now, or for first-degree murder, rather, is 15 to 25 years. So we wanted something that's more than 25 years, because that could also be the standard in the case of a juvenile for second-degree murder. So we wanted something more than that, and something less than what would be considered the functional equivalent of life. And there are some cases already where 60 years is considered to be that functional equivalent. So the window, as far as I'm concerned, is basically between 25 and 60 years. We talked to a lot of folks about this, and one of the more compelling cases was made by the District Attorneys Association, who unanimously said to us that it should be 35 years. We agree with that, and so do a lot of our co-sponsors.
All right, I'm going to bring another voice into this discussion who might not agree. Jack Kuna is a criminal defense attorney and a partner at the law firm Kuna. Welcome, Jack. So what is your take on this? Because one of the other standards, as we said earlier, is they have to prove whether a juvenile had a juvenile mind at the time in order to, you know, even meet this threshold of having a parole hearing. I mean, is that onerous? Is that realistic? How can you even do that? Well,
I think the Supreme Court of the United States has already found that juveniles have juvenile minds. So I'm not quite sure what that means. The Supreme Court in the Miller case, and the Supreme Judicial Court here in Massachusetts in the two cases that they decided in applying Miller to our jurisprudence, they recognize that there has to be a meaningful opportunity for something less than a life sentence. And it seems to me, quite frankly, that this bill is designed to have the appearance of the ability to have an individualized sentencing, when in fact, as a practical matter, it's denied.
It's a mandatory. I mean, the state and other states have not had all that great luck with mandatory sentencing. What's your take on this, though, in general? Do you think that a juvenile should have, I mean, I guess the simplest way to put it is a second chance. Some of these cases are just heinous beyond belief, and maybe not all of them, but some of them?
Sure. But as you said, Emily, there's no guarantee that somebody's going to be released. You know, one of the things that we hear in the public discourse often is, where's the justice for the victims? And quite frankly, nobody can imagine the depth of that kind of loss. However, what does it mean, justice for victims? Justice is a public justice, and public justice partakes of a number of different things. It partakes of the loss to the victims. It partakes of consideration for the act that was committed. And one of the things that it has to take consideration for is the youth of the offender. One of the things that the Supreme Court found, and it's based upon, I think, an understanding we all have about children, but it's also based upon recent science, which establishes it, which is that, yes, it's a heinous act, and yes, it was a deliberate act, but it was an act of a child. And therefore, that's something that has to be considered. Not that they're not going to be punished. Obviously, they're going to be punished. But in order to set out this kind of you know, it's got to be 35 years, and they have to prove that they didn't have that the act was influenced in some way by the fact that they had a juvenile brain when they clearly had a juvenile brain because they were children. And the notion also, as I understand the act, and the senator will correct me if I'm wrong, they have to prove beyond a reasonable doubt, by the way. And I think that there's a constitutionality issue there.
But Bruce Tarr respond to that.
Well, first of all, the Act is designed precisely, the statute that we proposed, to comport with the Constitution and to make a determination if the individual is going to have the benefit of these two decisions that they, in fact, did have a juvenile mindset. The fact of the matter is the brain science that these decisions are based on has been around for quite a long period of time.
These people
and we do
are adults
recognize
by the
that
time
distinction.
you're making that decision.
Well, that's true. They're adults getting the benefit of being cloaked with being a juvenile and having a juvenile mindset. The real question here is, did they have that mindset or did they not have that mindset?
How do you prove that when the person is 30 years beyond that?
Well, there are a number of things that actually the parole board is called upon to try to make decisions that are psychological in nature. That's why we have a parole board. That's what they do. That's why we gave them guidance last year in Melissa's law about the models they should use and the methodologies they should use.
That's where you're shaking your head.
This isn't a matter of psychology. This is a matter of physiology. It's about the way that the human mind develops. This isn't about whether somebody had some sort of psychological propensity to be a juvenile. It's whether or not, at this age, your brain is just not developed. And those are the studies that have been done, and they started in the 1990s, and they've been accelerating. They're still making discoveries about this. And it has to do with the way the brain actually physically develops. So when you're a child, you have a child's brain. The notion that you have to prove that as a child you have a child's brain, I think it's an absurdity.
All right. Bruce Tarr, Jack Kuna, thanks so much, both of you, for coming.